Good afternoon. As people cycle in, I'm just going to make sure that all is fine with the webinar. This is Daniel Bornstein. If you would kindly strap yourself in, we're going to have a great hour of learning. It is my pleasure, of course, to be providing you this webinar. And as I see attendees continue to cycle in, I'm going to wait to make sure that everybody is in, and then we will go through this PowerPoint slide presentation so that everybody is put in a position of having a better understanding of the law and a better understanding of where we are as a community in the Bay Area as it relates to landlord-tenant matters after, hopefully, the end of the COVID moratorium, though with a bit of caution, as many of you know, many people are starting to come down with the COVID infection or virus again. My hope, though, is that it remains under control. Perfect. So I'm going to get started. I'm Daniel Bornstein with Bornstein Law. Many of you know me. I've been handling landlord-tenant disputes for the last 30 years, and never in my life have I ever contemplated a time in my legal practice as complicated, cumbersome, and challenging as what we have just experienced over the last 36 months. And we are still, in some respects, very much involved in the residue from the COVID moratorium. And the goal today is just to give you a working knowledge of what we are experiencing. And my hope is that after this webinar, you come away with an understanding of at least that you're gonna need an attorney to handle a landlord-tenant dispute. The time of pulling a document from your file and serving a 3-day notice is a bit over unless you're really well positioned to understand all of the different nuances throughout the Bay Area. When I first started 30 years ago, there were 3 rent ordinances, 3 just cause eviction ordinances in the Bay Area, where we had Oakland, Berkeley, and San Francisco. And now we have about 13 to 17 different ordinances in the Bay Area. So it's particularly complicated. With that stated, let's turn around and get a 360-degree view of what's happening in the Bay Area as it relates to the current status of landlord-tenant affairs. One, I want to say this. When I put on a webinar, it is a group of people who are assisting me, and that includes people from the Berkeley Property Owners Association, the East Bay Rental Housing Association, the Small Property Owners Association, the South Alameda Rental Housing Association. And I just want to thank everybody who has helped me fine-tune this, because it is a particular difficult process. And the only thing I can say is that life has become more complex as we emerge out of COVID, while simultaneously recognizing that we are now under a state rent control ordinance, a state just cause eviction ordinance, and then local ordinances as well. Now, right now, many people are very excited about the culmination or the ending of the moratorium. However, you need to recognize that if you're not careful, you can still lose an unlawful detainer action because there are procedural errors that you make when you are not informed of the rules related to landlord-tenant laws in your jurisdiction. Further, each city which has an ordinance has an anti-harassment ordinance that can also create additional penalties when you make mistakes. There are numerous proactive attorneys who are happy to file lawsuits against you and your clients and property managers for failing to comply with the law. These lawsuits are very, very cumbersome, expensive, and challenging. They're 6-figure and 7-figure lawsuits. So you need to be careful before you engage in a dispute, making sure that you've done it correctly. Also, because of the politicized nature of housing in and about California, the Attorney General in California is also looking at egregious or malfeasant conduct by landlords and pursuing actions through their own rights to clamp down on those who are not behaving properly. Why I mention this is because all day long, I'm taking phone calls and emails of people who have gotten themselves into a dispute because they haven't been smart about being appropriate and understanding the laws before they start their action. Most importantly, at this juncture, you all know to be very sober and be very smart before you engage in pursuing a dispute with a tenant, whether it's a nuisance action, a non-payment of rent action, a debt collection action, a no-fault termination, such as a termination of a tenancy on a month-to-month basis, or an owner move-in termination. You're always going to be particularly careful before you get started and seek the advice of an attorney. Now, many of you or many of your clients who own real estate did not self-select into owning real estate, but may have inherited real estate and may not be keeping up to date with laws. I can only tell you from personal experience, there are many clients who simply didn't even know that there's a state just cause eviction ordinance, a state rent control ordinance that came into effect December of 2020, and they haven't even informed their tenants that the subject unit is exempt from state or local ordinance because they simply do not know the rules. The best real estate investors, the best real estate agents, the best property managers, the best individual property owners have a working knowledge of the law and stay abreast of changes in the law. And your job is, if you have kept your head in the ground and have imposed improper rent increases, have done things incorrect, correct it now. Be proactive in addressing the mistakes so that you don't fall into a situation where 2 years from now, you've collected rent over and above what was permitted, and now you have to disgorge those funds, or you haven't sent out the appropriate notice of exemption from state rent control and state just cause eviction rules because you own a condo and you're using a lease agreement that is stale. Any mistake made during COVID or before should be corrected before you embark on any action involving a tenant. I am happy to have that confidential conversation about what you should do in light of mistakes made in the past. Now, as the eviction moratoriums come to an end, notice requirements have remained in place, or they've even gotten more comprehensive and complex. Right now, as you own a piece of property in Hayward or in San Francisco or in Emeryville, you've got to ask yourself, what are the local requirements? What type of regulations I'm subject to? Do not pull notices off the internet. NOLO press notices, old California Apartment Association notices are no good. I recently had a client who had become very successful as a real estate investor tell me that they served their own notices and their notices are fine. I looked at the copyright from the notice that they were serving, and it was a copyright of a notice that was drafted in 2007. So the client who has had success in real estate believes that everything is fine. When I look at the 3-day notice, that was a notice that they've been using for now 16 years, I recognize it is not comprehensive. It is not code compliant. So at minimum, you need to get yourself updated documents. And not only do you need to get yourself updated documents, you need to get yourself updated documents for the jurisdiction in which your property is located. When in doubt, send over the document to my office. I'm happy to look at it and tell you what needs to get done to correct. And I can only tell you that laws have become so complex that my strong bias is that you have an attorney draft any termination notice, any cure or quit notice, any notice to cease, any 3-day notice to pay rent or quit, so that in the event the tenant doesn't cooperate with the demand, you have perfected your right to file the lawsuit and you don't have to start over. Many times I'm faced with the client sending me a 3-day notice that they have already served, and I have to tell them that the notice is incorrect and we have to start over. It's not a big deal if we haven't filed the lawsuit, but if you're in the middle of a lawsuit and you have a improperly prepared notice, you're going to have to start over, and that's where grief, anger arises. Remember, here are some simple mistakes that are typically made when we are faced with a non-payment or rent situation. And I know many of my clients who have been faced with tenants not paying rent during the COVID moratorium are eager to pursue rent demands, and they fail to appreciate that there are still simple mistakes that are being made that you need to be aware of before you start the process. Remember, we never demand more rent than is legally due. We never demand more rent than what is legally due. This includes many clients assume that if the rent is $1,000 for September and the late fee is $25, they can demand in a 3-day notice $1,025. Incorrect. A late fee is not rent. You can't demand it. You want to make sure that you draft a notice with the correct amount of rent. This can be very tricky if you have a tenant who only pays a portion of the rent each month and your ledger is very confusing. I'm happy to help you out. And under demand is always okay, and over demand is no good. Remember, even if your tenant hasn't paid you the rent, if you've got a habitability issue at your property, your heating system doesn't work, there is no water, the stairway is not safe, you've got clear habitability issues, there's a rodent infestation, you can still lose a non-payment of rent case. The tenant hasn't paid you for 30 months, but you can still lose that case because you have existing habitability issues at the property. I know it's painful where you have a tenant who has not paid you the rent and you want to demand the rent, but you've got a infestation inside the unit. You've got to spend the money to fix the infestation before you demand the rent. If there's existing building code violations, you've got to clear them before we demand the rent. As I've told you before, templated notices that you pull off the internet, old notices are no good. Make sure before you do anything, you've got updated notices. During the unlawful detainer action, and an unlawful detainer action is the trade word for an eviction action, the tenant is unlawfully detaining possession of the unit. Remember, you can't accept any rent from the tenant while you're in the eviction process. If you accept rent, you have to start over. This happens intermittently where I remind clients don't accept rent during the eviction process and their property manager fails to remember and deposits the rent. That reinstitutes the tenancy. It's a waiver of the eviction process, and therefore you have to start over. There are many, many, many ways you can lose an unlawful detainer action, and there are brilliant tenant attorneys looking for the mistakes that you make in order to allow their tenant to succeed in successfully defending the eviction action. So you always want to consult an attorney before you start the process. Many people may think they have the gumption and the knowledge to do this themselves, and I can only tell you that each week I'm reached out by a person who has started an eviction action and they end up having to sub themselves out and sub my office in, or we have to start over because they realize it's cumbersome and challenging and it's technically difficult, and only the most excellent real estate investors are able to handle a eviction action on their own, drafting the lawsuit and everything on their own. 98% of the people are not going to be able to do it. Let's get it right the first time so you do not have to start over again. Now, quickly, I want to go over the unlawful detainer process. I want to let you know right now, even with the eviction moratorium over, there is a cascade of cases being filed throughout the Bay Area. I was told in August there were 500 cases filed in Alameda County, and you could just imagine trying to swallow all of those cases in a court that has not been functioning effectively. So even though I can tell you that the unlawful detainer process typically takes 90 to 120 days, it can take longer because of the court delay that is occurring throughout the Bay Area. So this is the traditional unlawful detainer action process. I will tell you different jurisdictions have different nuances, but the court system is typically, we serve a 3-day notice to pay rent or quit. If the tenant pays the rent, the matter's over. If the tenant doesn't pay the rent, you can file the unlawful detainer action. If we are doing a no-fault termination, we serve a 60-day notice of termination of tenancy. The tenant has lived there over a year, so they're entitled to a 60-day notice. If we serve the notice and the tenant moves out, the matter's over. If we serve a 3-day notice to pay rent or quit and the tenant pays the rent, the matter's over. If they don't move out or don't pay the rent or don't cure the violation, then the landlord can file an unlawful detainer action. The tenant is unlawfully detaining possession of the unit. When people ask me, Mr. Bornstein, how long is this going to take and how much is it going to cost? I typically say once we file the lawsuit, it will take 90 to 120 days to work itself through. Sometimes it can be quicker, sometimes it can be slower, but you're looking at about 90 days. Pre-COVID, I would tell you 8 to 12 weeks. Now I've shifted it from 8 to 12 weeks to 12 to 16 weeks because of the difficulty of getting documents back from the court and the delay that's arisen because of the inertia that has set in post-COVID. Fastest, you serve the notice, the tenant doesn't respond, and you get a default judgment, and that's what we're looking at on the left of this chart. The hope is you get a default judgment, but that's unlikely because tenants all typically get free representation, and they get free representation from nonprofit housing providers or nonprofit law firms. And interestingly, that many people don't know, when we file the lawsuit, the court sends a letter to the tenants informing them that a lawsuit's been filed, and they also provide them information on who to contact to help them defend themselves in the unlawful detainer action. The tenant can file a pretrial motion such as a demur or a motion to quash, and then there's a hearing, and that delays matters. The hope is that if the tenant doesn't file a motion and doesn't get defaulted, they file an answer. Once the tenant files an answer, we set the case for trial. If they demanded a jury trial, a week before the trial, there's a settlement conference. The trial is the following week, and the trial can take 1 to 4 days. If it's a jury trial, if it's a court trial, it's relatively short. Today, my office was in Alameda County Court. Tenant didn't show up yesterday for the settlement conference, didn't show up today for the trial, and we have a prove up where we get a judgment because the tenant didn't show up. They did file an answer, however. Generally speaking, people ask me how much it's going to cost, and I say, look, I don't know. I don't know how much it's going to cost because I'm not in control of the biggest variable. The biggest variable is which attorney they get and how hard they fight. I can tell you 90 to 120 days. Typically, my retainer request is between $5,000 and $7,500 per file. That's a retainer. It gives me sufficient funds to allow me to handle the matter. My hope is that it gets resolved for less than that, but I really don't know. A jury trial can cost $15,000 to $20,000. And the tenant attorney knows that. So when you get to the settlement conference, even though the tenant owes you 4 months of rent and owes you $8,000 because rent was $2,000 a month, the tenant attorney knows that it will cost you $20,000 to go to a jury trial, and the tenant is judgment proof. So at the settlement conference, the tenant attorney will say, you know what? They'll move out in 60 days waive the past due rent, waive the debt for 60 days, and give back the security deposit without offset. And you have to recognize that that may be painful, but losing $10,000 of potential rent money is less expensive than a $20,000 jury trial. So the economics of the dispute typically create a situation where you end up losing the debt that is owed only because the cost of going through with the trial is more expensive. And remember, if you get a judgment against a tenant, you will be able to recover possession of the premises through a sheriff's eviction. You will get a piece of paper that says the tenant owes you money, but collecting that money is totally different. And remember, a judge doesn't immediately take the tenant upside down and shake the money from their pockets. It's just a piece of paper. Once it says the tenant owes you $8,000 for the judgment, you then have to go and collect it. Collections agents take 50% typically of whatever they collect. So after this whole process, if you're lucky, you may get $4,000 if you go through collections, and the collections agent will take $4,000 as well. Generally speaking, chasing tenant debt is not a high upside for you. Recovering possession of the premises is the most important thing because your real estate investment has the most value to you. Your real estate investment may be millions of dollars. Your tenant lost rent may be tens of thousands of dollars. It's still painful, but you've got to be smart about the dispute. So let's move on after that soliloquy. Remember, courts have geared up now. The courts are open for unlawful detainer actions or eviction actions. However, I want you to know, San Francisco, they can't handle the volume of cases that are upon them, and they're limiting the amount of cases that are being set for trial each week. I'm sitting and waiting with some of my cases for me to get a court date and settlement conference. So the delay is causing inertia. And unfortunately, as I said before, during an eviction action, you cannot collect the rent. So the delay is increasing the debt owed to you. You can't collect it, and we're waiting for a courtroom in order to be able to finally recover possession of the premises. Getting the courtroom, getting the settlement conference, getting closer to that trial gives you the maximum leverage to get to a settlement with the tenant. Remember, inertia serves the interest of the defendant, and you as an owner want to pursue as rapidly as possible getting to that trial date so that you can get closure on that relationship. Oakland, Alameda County, getting the lawsuit filed and back from the court a couple weeks. It used to be we could go to the court on that day, file a document and get it back from the clerk immediately. Now we're submitting the document and waiting for that document to be processed. After serving the document and submitting the document for a default judgment, because the defendant did not actually appear in the case, it's taken me 2 weeks before the default is entered. So what used to be a relatively quick process is now a delayed process. In Contra Costa County, I've gotten a judgment, and then I go to the sheriff to schedule the sheriff's eviction, and they give me a sheriff's eviction 4 weeks out. So I'm sitting with the judgment, and I'm not able to recover possession for another month or 6 weeks. That's infuriating. Welcome to the Bay Area. I can only tell you that I've never been more frustrated. I've never been so empathetic and sensitive with clients, but I've got to be blunt and direct. I don't control the delay. I try to make things as quickly as possible. There is a deluge of unlawful detainer actions that are going to be filed, that are being filed. I've never had a more busy time in my practice. I think over the last 4 days, I had up to 35 unlawful detainer actions that we could file after having 35 notices out there waiting to determine if a tenant will pay or not, or vacate or not. So this is not atypical. And I believe that if you talk to many attorneys who are handling landlord-tenant disputes on the landlord side, they're all going to say, we're very, very busy because there's such a pent-up demand for unlawful detainer lawsuits because you have many people inside units where they have not been paying the rent. Now, What's important is get a survey of what's going on in the different jurisdictions so you have an understanding. I can only tell you that I wish things were as easy as it were pre-pandemic. And pre-pandemic, I was also bemoaning how things have gotten complex. It's only worse. Berkeley. So many of you, if you go to sfgate.com, you'll look, there was a meeting for the Berkeley Property Owners Association, a social mixer, and they were in good faith meeting to at least acknowledge the end of the moratorium that ended September 1st. There were protests in front of that meeting event, and then there was actually physical altercations. Very unfortunate, but it really demonstrates the polarization that is existing in places that are like Berkeley. Although, of course, Berkeley is somewhat of an outlier, but other places in this Bay Area are also becoming polarized between landlords and tenants in a way that is not very helpful for our community. And my big beef with all of these laws is that it further polarizes people into two different camps, when as a community, we need to work together to end this housing crisis. The moratorium ended September 1st. And that means that if the tenant hasn't paid you rent for September 1st, you can demand it in Berkeley without the risk of a claim of a COVID hardship. The chronology of the eviction moratorium in Berkeley was as follows. We had the March 17th to April 30th period where that debt was converted to consumer debt. We had the recent 4-month transition period where you could demand rent, but if a tenant alleged the COVID hardship, you could not proceed with the non-payment of rent case. And then we have September 1st, where we are back to the traditional method of handling landlord-tenant matters in Berkeley. I am now being tasked with serving notices demanding September rent in Berkeley. I am typically reticent to demand rent from that May 1st to August 31st period because a tenant has an easy way to stop the process by asserting a COVID hardship. And therefore, I'm focused on September 1st debt going forward in Berkeley. Oakland. Oakland has astonished me in its complexity. I used to suggest that Berkeley and San Francisco's rent ordinance, just cause eviction rules were the most pernicious. And now we have Oakland that has really shocked and stunned me with its difficult nature. Let's recognize that right now the moratorium in Oakland ended July 15th. We have been serving notices demanding rent starting in August, but there are a number of issues you need to be familiar with. One, we're always wondering and making sure we know when the building was built. And that's for all properties throughout California because state rent control, state just cause eviction rules have certain threshold dates. Each jurisdiction has threshold dates for when a building is covered under the rent ordinance or not. We're looking at 10 years in Berkeley. Remember, a tenant cannot be evicted for refusing to renew their lease. For no fault evictions, such as an owner move-in eviction, where you want to recover possession because you're moving into the property, just like in San Francisco, if there's a child that is in that household or there's educators in that household, you're going to have to wait until the end of the school year. Very important point number 4, you've got to register your unit. If you do not register your Oakland unit, it's a defense to the eviction action. In San Francisco, you've got to register your unit. If you don't register your unit and get your quote unquote license to raise the rent, your rent increase cannot be enforced. Another cruel aspect of Oakland, which is different than any other jurisdiction, is there is now a threshold requirement of the rent debt being high enough before you can serve a 3-day notice to pay rent or quit. And we'll see that in the next slide. Also, if you do have to pay relocation payments in a no-fault eviction, such as an owner move-in eviction, and you do not pay it, it's a defense to the eviction action. If the unit is not registered, it's a defense to the eviction action. So we want to be careful about that. And also for those of you who have accessory dwelling units, there are other nuanced rules. So you really, when you talk to me about your property, I'm always going to ask you, when was the property built? How many bedrooms does it have in Oakland? Are you registered with the rent board, with the rent registry? And I have that in my intake form. My intake form used to be 2 pages. Now it's a 4-page intake form. I really need to do a thorough protocol before I know what I can do on your behalf and what we need to correct before we start any process. So what I mentioned before, in any other part of California, if a tenant has a 1-bedroom unit and their rent is $1,200 a month and they paid you $1,000, you can serve a 3-day notice to pay rent or quit for the $200 that they did not pay you. And if in 3 days after serving that 3-day notice, 3 court days, the tenant didn't pay you $200, you are entitled to file an unlawful detainer action seeking to recover possession of the premises because of non-payment of rent. In Oakland, the rules have changed. What we need to have in Oakland is debt that has accumulated large enough that it permits you to demand the rent. So for a studio unit, you have to have $1,658 in unpaid rent before we can serve a 3-day notice. A 1-bedroom is $1,969, a 2-bedroom is $2,405, a 3-bedroom is $3,144, and a 4-bedroom is $3,706. What does this mean? It means I had a bunch of wonderful clients reach out to me August 1st and say, Mr. Bornstein, I've been waiting for 3 years. My tenant owes me $60,000 and I know the moratorium's over and I know we're going to focus on August rent going forward. So there's no COVID defense. I need you to serve a 3-day notice. My tenant did not pay $1,000 for the rent in their 1-bedroom unit for August. I say, what's the rent? You say $1,000. I say, I'm sorry, but because this is a 1-bedroom unit and they only owe you $1,000 for August, I can't prepare and serve a 3-day notice to pay rent or quit. The threshold amount is not high enough. We need to wait until September to see if they pay in September to determine if we can serve the 3-day notice. So that same client comes back to me September 2nd, say, Mr. Bornstein, the tenant hasn't paid me rent for September as well. They now owe me $2,000 for September rent and August rent. And then I say to them, okay, I can serve a 3-day notice to pay rent or quit. Got it? Now, if I serve a 3-day notice to pay rent or quit and they don't pay it, then I can file the lawsuit. So this is different than other parts of California. You need to be aware of this chart. I'm not going to get right now into the complexity of the CARES Act and whether you need to serve a 30-day notice or a 3-day notice. But for the ease of this process right now, the most important thing is you recognize you're registering your units and you're also chronicling the debt and recognize in Oakland, there are these requirements before we can demand the rent. And you say to me, Mr. Bornstein, I have a wonderful situation where I own a 2-bedroom unit. It's a Oakland Housing Authority unit, and the Oakland Housing Authority pays $2,000. The tenant pays $400, and the tenant hasn't paid me $400 for August and September. I say, oh, so that's an $800 debt. We're going to have to wait a long time before I can demand the tenant's portion of the rent because $2,405, it must be owed before I can do it. And this is an example of how pernicious this aspect of this new law is in Oakland. I didn't make it up. It came into effect in the spring of 2023. Thank you, Oakland. And I can only wait for some attorney to challenge this as unconstitutional, as violative of California law, but it hasn't happened yet. Let's move on. Other things. They also have new rules regarding breaches of leases. The breach must create injury to a landlord. It must be substantial and it must be agreeable in writing. So small breaches of a lease agreement are something that I'm not going to act upon. Again, repeated, if you're not registered with the rent registry, you're going to subject yourself to an inability to proceed with rent increases, respond to tenant petitions, and also pursue unlawful detainer actions. Another point, for those of you who have a rent-controlled unit, you cannot raise rent beyond the allowable amount until July 1st, 2024. I believe it's 2.2%. There's so many percentage increases nowadays throughout the Bay Area, I have to remember, but I believe it's about 2.2%. Check with me if you have questions, but you can't bank rents and impose them at this time because that moratorium on rent increases is still in effect in Oakland until July 1st, 2024. San Leandro. Many of you don't know that San Leandro has a ordinance. Wanted to let you know that the eviction moratorium has ended July 31st. For pre-COVID debt, prior to July 31st, they have 180 days to pay. They do have to provide a claim of justification for that COVID impact. What I would tell you is if you own property in San Leandro, before you serve a notice, you want to contact an attorney. What I'm focused on from a strategic point is not demanding the rent in the past through a 3-day notice, but instead pursuing rent debt that has accrued post that moratorium, which would be August, September in San Leandro. Now, there are other ordinances in Alameda. We have Emeryville, we have Hayward, and I just want to let you know that if you're a property manager or a real estate agent and you're involved in properties that are out and around the whole Bay Area, you really do want to take a deep breath before you give any advice, suggest a client contact an attorney, because you really do have to know what jurisdiction it is, what the rules are. Some jurisdictions have a more mild eviction process. Some jurisdictions have a more pernicious eviction, just cause eviction rules. And then remember, if it doesn't fall within a local jurisdiction's eviction ordinance, it may be subject to state rent control and state just cause eviction laws, like a property in Walnut Creek. A 5-unit property built in 1965 in Walnut Creek will be subject to state just cause eviction, state rent control. In Contra Costa, most of the locales are governed by state law, such as Walnut Creek, but we do have some locales that are going to be subject to their own local regulatory regime. And the rule is, if the local regulatory regime is more strict, that's what you follow. Concord. Concord's a big city. I want you to know it does have a milder ordinance. Leases must be 12 months. And if a tenant objects, a 6-month lease is offered. Remember, we've got so many different rules in Concord. A displacement of a tenant through a no-fault eviction, you've got relocation payments. There's also a anti-harassment ordinance, and you folks need to be aware with Concord, there is always discussions of imposing a new just cause eviction rent control ordinance. I can only say that as housing becomes more politicized, as many people suffer the economic effects of COVID, more and more tenant advocacy groups throughout the Bay Area are pushing council members to add a just cause eviction ordinance in their community. The attorneys, the real estate investors who are watching the news, who are staying abreast of things, are the ones who know about it. For instance, Antioch, Pittsburgh, all of these different places are generating new ordinances, and you just have to be familiar with it. And the jurisdictions that currently have ordinances are fine-tuning them, making them more strident, beneficial to tenants at the expense of landlord or housing providers. Richmond, California has a just cause eviction ordinance. It has a homeowner protection ordinance. You need to recognize that all units have to be enrolled in Richmond. There are rent increase regulations, and there are also relocation payment obligations. Oftentimes, investors look in Richmond, they find nice price points on property, nice price per unit, nice price per square feet. You better be familiar with the ordinance, because many of these properties are like San Francisco, Oakland, and Berkeley. They look good, but the question is, are you going to be able to reassess the rent, reposition the unit, or are you going to be buying a property that is inherently constrained because the ordinance precludes you from recovery possession unless you pursue a buyout agreement of some sort? So be advised. I do want you to know that I am also a real estate investor. I have a property management company, and I am conversant in being able to look at a property and give you some gut sense of whether it is a property that, if you purchase it, there are options and strategies to create upside for yourself, or whether it is something that is going to exist in a state of under market value because there's not much you can do with it. You can still buy it, but you want to buy it at the right price point. I'm always happy to provide you the opportunity to have a gut check on a real estate investment. It's a half-hour meeting, and you'll get a good sense of whether this is something viable for you or not. It's always your decision, but with real estate and big ticket investments, when you have tenants in rent-controlled units, you really want to know your strategy post-purchase before you get yourself involved in a poor decision. Now, there are many, many people who are involved in holding COVID rent debt. The client who was in court today, we recovered a judgment for post-COVID debt, and we will be recovering possession of the unit. But the tenant owed the client in excess of $100,000. The judgment was for rent from August through the present. But that COVID debt, we were not able to recover in the unlawful detainer action. The COVID debt, there's many different ways to handle it. Small claims court is an approach. There is a whole regulatory regime where you can recover COVID rent debt in small claims court. There is not the jurisdictional limit of $10,000 for a COVID-related debt. It can be larger. The problem is small claims court is often kangaroo court. You may not have a real judge. You may have a volunteer attorney serving as a judge, and you can be seriously compromised by a poor decision in small claims court. So if you're holding large rent debt from COVID, you may want to consider going through with hiring an attorney and filing a regular lawsuit in Superior Court to recover a judgment. I'm happy to always discuss that with you, because going forward and spending money on an attorney only to get a judgment for a tenant rent debt that you may not recover, you have to make a decision as to whether it's worthwhile. If you have a tenant who has a great job, who moved out, and they owe you $40,000 of COVID debt, and you know they're employed in Silicon Valley, well, that may be a prudent decision to hire an attorney to pursue the debt in regular court. If the tenant you know is judgment proof, is financially jeopardized, is economically disadvantaged, that rent debt may not be something you want to do much with, except for go to small claims court. We will talk about that if you have a meeting. I'm always about making good business decisions for you, and I'm always considering whether it is worthwhile to actually utilize an attorney in order to pursue that debt. Another point, I often, if you have a tenant who has exceeding amounts of rent debt, instead of going to a eviction action, I may pursue a negotiated voluntary move out to recover possession of the premises in exchange for some sort of debt relief, because I'm looking to get a quality tenant inside the premises, start building cash flow from that real estate as soon as possible. And if a tenant is willing to vacate quickly, I may be willing to waive that debt through a negotiated buyout. Another point, 1099-C, you could potentially issue a 1099-C on waived rent debt that would trigger a taxable event for a tenant. This is something that could give you leverage. My strong advice is contact my office if you're considering waiving rent debt and wanting to issue a 1099 in order to get some leverage in the discussion with the tenant, or contact a qualified tax professional to discuss this. It's a nuance that has been presented to me. Admittedly, I have not pursued this myself, but it's out there, and it may give you a little bit of discussion with a tenant that you may say to them, look, if you vacate, I may just simply forgive the rent. I may not issue a 1099, and you may be in a much better position to transition out with a complete waiver as opposed to getting involved in a dispute with me. So with that stated, remember, multiple different ways to collect the debt or get a judgment. Remember, a judgment does not mean you're getting paid. It just means that you have a piece of paper that they owe you the money. I do want to mention, in San Francisco courts opened up sooner than Oakland and Berkeley. I've been going through eviction actions for non-payment of rent in San Francisco. And what I've been doing is often, because there's still third-party money available in San Francisco, we are using the non-payment of rent eviction process to enter into an enforceable settlement where the tenant gets third-party money to pay COVID rent debt, promises to continue to pay the rent timely. And if you don't get the COVID rent debt paid, if they don't pay the rent timely, you get recovery of possession of the premises without a trial. It allows the tenant to remain in possession of the premises, but allows you to have confidence that you're either getting the money or you're going to have them removed. So oftentimes it is a strategic decision to pursue an eviction action in order to find a way to gain maximum leverage to recover that debt. If you have any questions about it, give me a call, email me. I'm always happy to discuss strategy, and the strategy may change depending upon the nature of your tenant, the location of your property, whether it's a condo, single family home, or a multi-unit property, and what your ultimate goals are for the property. Because if you tell me, Daniel, I do not want that tenant to remain in, I'm not interested in the money, then we seek recovery of possession. If you're saying to me, Daniel, I'm happy to take the money under a stringent stipulation, then that's what we're going to try to ascribe to, because I'm putting a lot of money back into my client's pocket by simply entering into strict stipulations for entry of future judgment to recover that rent debt. Remember, being a tenant attorney can be much more lucrative than being a personal injury attorney. Tenant attorneys have multiple ways to file lawsuits, and under many of the local jurisdiction rules, the just cause eviction rules, penalties for violating a eviction ordinance, the damages are tripled and the tenant attorney gets attorney fees. So what looks like a simple dispute becomes a couple $100,000 payment to a tenant and their attorney. Anti-harassment ordinances create opportunities. Tenants are entitled to treble damages. Wrongful evictions, where you do an owner move-in termination and never move in and then sell the property, those are seven-figure cases. You want to always be careful, because there are brilliant tenant attorneys looking for tenants who are harmed by imprudent behavior by housing providers, and then they sue. And I want you to recognize today, if you own rental property throughout the Bay Area, you want to have a landlord insurance policy. You do not want to have a homeowner's policy. A homeowner's policy will not cover you. If any of you that are here own a condominium with a renter, or own a single family home and you have a homeowner's policy, or you have a single family home with an in-law unit and you have a homeowner's policy, you're potentially at risk. So get yourself a landlord insurance policy, because filing lawsuits against housing providers is very, very lucrative. And tenant attorneys are looking to zealously represent their tenants. They're looking to make money through the mistakes made by folks. And there's only so much I can do. And I get a lot of misery when a client comes to me, say they've been sued because of a wrongful eviction. And I ask them, do you have insurance coverage? And they say they have a homeowner's policy. They don't have the proper coverage. And then I tell them, you're going to have to defend yourself by hiring an attorney, paying the attorney, and you're also likely going to have to settle this case because there's liability. And we're looking at 6 figures. And many of you don't have that available. And I can just see the life drain out of people because of not being proactive in getting that insurance coverage in place before you own property. And for you real estate agents who are representing a client who is buying a property that's tenant occupied and they want to do an owner move-in termination to displace the tenant because they bought it to move in, they need to get landlord coverage. And then after they recover possession of the premises, we can talk about transitioning out of that coverage after they have waited the necessary period of time. But we want to always have that landlord protection policy. It's getting more and more difficult, as people know, about even securing insurance for your property in San Francisco, in California. And I can only tell you that wrongful eviction coverage and a landlord protection policy is inherently necessary because of the nature of what we're dealing with throughout the Bay Area. One very important point, during COVID and during now, I want you to know where a tenant misbehaves in a way that is egregious: physical violence, drug dealing, vandalism, graffiti, throwing stuff out of a window, threatening people, intimidating property managers, grabbing and damaging items, engaging in behavior that subjects the person to a harassment restraining order, we are able to assist immediately. Whatever the rules in a local jurisdiction, they always give the right to terminate when someone is a nuisance or engaged in illegal conduct. And throughout COVID, with lots of people inside multi-unit properties getting cabin fever, the misconduct arose and we were able to pursue it. The real question is, are we talking about misconduct like a party at night that disturbed the quiet enjoyment? Or are we talking about methamphetamine use and sales inside the unit? It's one of degrees. In my 30 years of expertise, I can always provide you a gut feel for whether this is an immediate termination or whether we have to go through the process of serving, whether it's in San Francisco, a 10-day warning notice, then a cure or quit notice, or we segue straight into a 3-day notice. Sometimes the behavior is so egregious, I need to get a restraining order immediately, but a restraining order with a landlord-tenant context is typically not the same thing as an eviction. A restraining order is not going to oust the person from their rental unit. It may keep the person 10 meters away from people, but it doesn't solve the problem of removing the person from the premises. We do get TROs and we do get harassment orders for someone who's harassing night staff. But in the end, the best approach is to commence the eviction process because that removes the person from the property. And remember, when you have finally recovered possession of the premises through an eviction, the occupant is no longer given the right to occupy. If they come back to the property, they're deemed to be a trespasser and they can be arrested for trespass. My office has handled thousands of displacements as a result of improper behavior of the course of 30 years. We're very comfortable with it. So you do not need to be victimized, and other people in your units, other members of your tenant community do not need to be victimized by people who are engaging in behavior that's abnormal or terrible. I will tell you, there's a lot of mental illness out there. There's a lot of addictive behavior. We do face the consequences of having to deal with someone who has a disability and engaging in poor behavior. When in doubt, contact my office. I'm happy to handle it for you. As I mentioned before, if we can avoid going to court and doing an eviction, our best preference is to do a negotiated voluntary move out. We do buyout agreements all the time. The information before you is what is typically what I need to do a negotiated agreement to vacate the premises. However, whether you're in San Francisco, Berkeley, Oakland, Richmond, Alameda, there are different rules regarding the protocol you must follow to do a buyout. There are different disclosure requirements. There are different rescission requirements. So if you decide that you're going to pursue a negotiated voluntary move out from a tenant, contact my office. I'm happy to give you information on how to do it correctly. If you don't do it correctly, then it's not enforceable. So for instance, in San Francisco, the tenant has 45 days to rescind the agreement. The rescission has to be embedded in the contract. If you don't give them a disclosure before you actually do this, you haven't complied with your obligations. If you give the tenant money to move out and you didn't comply with your obligations, you can give the tenant money to move out and they can turn around and sue you for wrongful eviction. So you do want to do this correctly. And it isn't brain surgery. It just needs to be done properly. Berkeley, Oakland, San Francisco have different protocols. Some places do not have any protocols, and I can do it less expensively for you. Most importantly, you know that you're not just giving a tenant money to vacate, you're giving a tenant money to voluntarily vacate and give up any claims arising out of their tenancy, even those claims they don't know about. So it's not just cash for keys, it's money in exchange or a rent waiver in exchange for you voluntarily vacating and promising to give up any and all claims arising out of your tenancy, even those claims you don't know about. So for instance, if you don't do it correctly, you give a tenant $10,000, you don't have a proper buyout agreement, the tenant can move out. You give them $10,000 and then they develop a respiratory illness, claim that there was mold inside your unit and sue you for mold and personal injury because they got damaged because of the mold inside your unit. A buyout agreement properly prepared will insulate you from that situation. So you're looking for a transition for some benefit given to the tenant in exchange for a complete waiver of claims, even those claims the tenant doesn't know about. So with that stated, I have in 1 hour given you a relatively thorough but quick review of different jurisdictions' rules, some of the issues that we are faced with today, and it is my pleasure always to assist. I know that this webinar is quick, and I know that it also results in you having many questions. If you have a question, email me. If it requires a meeting, I'll let you know. If I can answer it quickly, I will. Please let your clients know that I am always distributing information by e-blasts, by uploads to my Facebook page to inform people about new laws that are evolving in the courts and in the different legislation that's involved within city councils or within the state. Staying informed with me and following my social media will help you stay educated about the industry. It's a pleasure and privilege to do it. I have wonderful people who are helping me do this all the time. And I can only say that it's work, but it's something I'm very proud of. And I receive a lot of good feedback from people thanking me for doing it. Please, if you have other people who are involved or interested in real estate in the Bay Area, get them involved with my social media so they stay smart and stay out of trouble. With that stated, I want to thank everybody for your participation. We had over 150 people in this webinar. And again, it's tricky, it's complex. Don't take a step without taking a deep breath and asking yourself, am I doing this right? Do I need an attorney? How can I better ensure that I don't make a mistake? With that, have a great rest of the day. And thank you for your attention. And thank you for the opportunity to help you out.